Assalamu alaikum. Sadia Bukhari, Director, Mohsinini Resource Center. Today we are going to discuss findings and recommendations of a commission that was formed for the elimination of forced and bonded labor in Islamabad. Sequence of my presentation: Manzoora Bibi versus SHO PS Noon Islamabad and others, Commission members, special invitees, terms of reference, methodology adopted, data, laws enforced in the ICT, international and legal obligations, changes introduced by Punjab, findings, recommendations. On 30th December 2020, a habeas corpus petition was filed in the Islamabad High Court. 2nd January, the detainees were recovered. On 2nd January, an order was passed to constitute a commission to inquire into and make recommendations for the elimination of bonded labor. The commission members were Mr. Hamza Shafkat, Deputy Commissioner, Islamabad Territory; Mr. Muhammad Sabir, General Secretary, Pakistan Bhatta Mazdoor Union; Mr. Danial Hassan, State Council, Advocate General Office; Mr. Adnan Haider Randhawa, Advocate High Court; Mr. Umar Ijaz Gilani, Advocate High Court; Sadia Bukhari, Council Member, Human Rights Commission of Pakistan; Mr. Shakil Anjum, President, Islamabad Union of Journalists. Special invitees for this commission were Syed Hasnat Javed, former Director General, Labour Department, Punjab; Mia Muhammad Banyamin, Country Manager, Pakistan, International Labour Organization; Mr. Ghani Muhammad, Labour Officer, Magistrate, Labour Department, Islamabad Capital Territory; owners, representatives of brick lanes in ICT. Terms of reference for this commission were: conduct a survey and carry out inspection of all the brick lanes established in the Islamabad Capital Territory; collect the record and data of the labourers employed in the brick lane; examine the laws enforced in the Islamabad Capital Territory relating to protecting the rights of the labourers; examine the mechanisms relating to registration of the labour employed within the Islamabad Capital Territory, whether in the industry or as domestic help; assess the enforcement level of the enforced laws; ensure that the public functionaries take appropriate action to free those labourers who were found to be victims of bonded labour in any form or manifestation; any other matter which, in the opinion of the Commission, needs to be considered for elimination of the menace of forced and bonded employment. The methodology that was adopted by the Commission was on-spot inspection of different sections of the workplace, visit of residential quarters of labourers by Sadia Bukhari and Sanya Pasha, the AC. Local intercept interviews were conducted, public consultations were held, focus group discussions were carried out, desk review and interviews. Other resources that were used were interviews with bricklane owners, the FIR was examined, the witness statements were collected, Darshan Masih case PLD 1990, Supreme Court 513, report of Mr. Khalilur Rahman Ramde, Advocate General, Punjab, report by Ms. Asma Jahangir on condition of women and children at Brick Lane, report of Lahore High Court Bar Association, report of Labour Union, report of Bhatta Owners Union, report of Punjab Labour Welfare Department. According to the data that was collected by the Commission, total number of labourers employed in brick lanes is 1,970. Total number of families living in brick lanes are 398. Total number of women and children less than the age of 14 working on brick lanes are 90. Average income of the laborers is 6,000 to 7,000 Pakistan rupees per week. Average income of the laborers, then the availability of government school near brick lanes. Government primary school exists near only 23 brick lanes. Availability of government health facility near brick lanes. Only 14 government dispensaries exist near brick lanes. Laws enforced in the ICT, the Mines Act 1923, Apprenticeship Act 2018. Every statute provides its own definition of who a laborer is and creates a parallel mechanism for enforcement and adjudication, which is a very big challenge. International and legal obligations. The International Court of Justice has declared protection from slavery as an obligation erga omnes arising out of human rights law. 36 declarations and obligations on the elimination of slavery and forced bonded labor. United Declaration of Human Rights prohibits slavery and servitude. Article 4 provides free choice of employment. Article 23, Section 1. International Convention on Civil and Political Rights was ratified on June 2010 by Pakistan. International Convention on Economic, Social and Cultural Rights was ratified in April 2008 by Pakistan. Sustainable Development Goals. Goal 8, Target 8.7 is for the elimination of modern day slavery. Changes introduced by Punjab. The most regressive change is the allowance of vicious debt up to 50,000 rupees, which has opened a window for the continuance of debt slavery in Pakistan. Provision of a registered contract overwhelmingly tilts in the favor of the bricklane owners, thus fortifying slavery. Findings of the Commission are: practice of extending vicious debt is overwhelmingly prevalent in the entire sector of bricklanes without exception, which has resulted in sector-wide continuation and prevalence of bonded labor system in brick lanes despite its abolition by the Abolition Act 1992. Responsibility of the continuation and prevalence of the bonded labor system rests entirely upon the owners of brick lanes, the bonded labor being vulnerable and at the receiving end of the system cannot be blamed for the same. No brick lane is registered either with the Labour Department, the Social Security Department, institutions, or with any other government authority relevant to the issues in hand. Labourers working in brick lanes who are found to be in debt bondage mostly, ICT, or with any other social security institutions, nor is there any legal mechanism available for registration of their contracts with any department, which can be effective first step to curb the menace of debt bondage. Wages are not paid on a daily, weekly, or monthly basis. Instead, a complex accounting system is in vogue, which cannot be comprehended by the illiterate and simple bonded laborer, wherein accounts are settled on every Thursday. Part, mostly dominant, of the earned wages is adjusted against the repayment of vicious debt and fines, if any, and the laborers get only a meager subsistence allowance to survive for the succeeding week. Most of the bonded labor lives at the premises of brick lanes along with their families. Women folk and children are encouraged to informally work with the heads of their families. They are encouraged to work as a family unit instead of as individual laborers. This practice violates many of the labor rights of women folk and children. Should they be formally employed as individual laborers, their rights like minimum wages rights, maternity leave, sick leave, etc., would be protected under the relevant labor laws. Presence of women folk and children serves as a collateral security of the vicious debt, along with their valuables like motorcycles, animals, etc. Laborers who work without families are usually seasonal. They also work in debt bondage, but their bondage ends with the end of season. Many laborers working at brick lanes do not have any identification documents like ID card and B forms, etc., issued by NADRA. The Commission met many persons of Afghan refugee heritage who work at brick lanes. Since their children have been born on Pakistani soil, they are clearly entitled to Pakistani citizenship under Section 4 of the Pakistan Citizenship Act 1951. NADRA does not grant them identity cards. As a result, most had no identification documents whatsoever and are living in a state of statelessness. Some claim to have Afghan origin card, but those two expired in 2015. Lack of any effective citizenship documents results in these workers facing problems while seeking medical attention in public health facilities as well as exploitation at the hands of the local police. This makes them uniquely vulnerable to debt bondage. Working conditions at the brick lanes are hazardous. The laborers are not provided with any protective equipment except gloves while performing hazardous tasks like igniting coal and picking bricks from the brick lane, etc. The laborers are provided with residential quarters, but they are rudimentary and shabby accommodation near the brick lane quarters with inadequate sanitation facilities. Children are not formally working at the brick lane, though they are often providing a helping hand to their parents. The practice of child labor has largely been eliminated at brick lanes, and no child works at a brick lane other than with his her family or their relatives. Children living with their parents at brick lanes have little opportunities of education for which responsibility lies collectively with the parents, owners of brick lanes, and the state. Very few children of laborers are getting education. There are no health facilities whatsoever near the brick lanes. The laborers working at brick lanes end up incurring additional debt whenever they require medical attention, since they do not have any sort of health insurance, nor are public health facilities available in close proximity to brick lanes. Sorry about stumbling. Vicious debt is very much being exercised in the environment, and modern day slavery is being practiced. Recommendations, therefore, of the Commission under these circumstances are the following. Vicious debt and resultant debt bondage is overwhelmingly prevalent in the bricklaying sector in ICT, despite the fact that both are abolished and outlawed first by consent judgment of Darshan Masih case in 1989 and then by Abolition Act 1992. The laws should be dealt with a iron fist, and vicious debt must not be allowed to continue and prevail under any circumstances. It is also pertinent to mention that after devolution, Punjab has supplemented its adopted Abolition Act 1992 with Punjab Prohibition of Child Labour at Brick Lanes Act 2016, whereby it has introduced many regressive changes in the Abolition Act 1992 with which the Commission is not in agreement. The most aggressive change is the allowance of vicious debt up to 50,000 rupees. The laws should be dealt with an iron fist. A form appended with the law has been constituted. The terms of the contract overwhelmingly tilt in favor of the owners of Bricklin and hence favoring the continuation and prevalence of bonded labor. The Labour Department ICT shall ensure registration of all bricklins under the Factories Act 1934 within 3 months commencing February 1st, 2021. The Labour Department ICT shall also ensure execution of employment contracts and the maintenance of prescribed registers under the relevant labour laws. The National Database and Registration Authority should be directed to ensure issuance of CNICs to bricklin workers and registration of their families' children by sending special teams to bricklins within 3 months in collaboration with the Labour Department ICT and the bricklin owners. No family should be made or allowed to work as a single unit. Instead, each member of a family shall be free to work under a separate contract with all the associated labor rights available to him/her about labor laws. No child below the age of 14 years shall be employed or permitted to work at any bricklin as prohibited under Part 2 of the Schedule of the Employment Children Act 1991. Being part of the building and construction industry, the Chief Commissioner ICT may be directed to designate an inspector under Section 7 of the Employment of Children Act 1991 for the enforcement of the provision of the said Act. Every engagement or appointment of a worker at a bricklin should be subject to a written contract in the prescribed form, drafted preferably in Urdu and regional languages widely spoken in ICT such as Punjabi and Pashto. Necessary directions may be issued for preparation of the prescribed standard form contract. The Commission does not endorse the Form 1 made under Section 3 of Punjab Prohibition of Child Labour at Bricklins Act 2016, being regressive in its terms and violative of many of the provisions of Abolition Act 1992. Payment of wages. Payment of wages shall have to be made to the labourers on daily, weekly, fortnightly, or monthly basis as agreed upon between the labourer and bhatta owner regularly. No deductions are to be made from their wages for the damage, losses to bricks caused on account of rain, and it shall be borne by the owners of the bricklins as per the judgment of Darshan Masi case. No bricklin owner manager shall give any vicious debt to any worker in any mode or form whatsoever. Any such vicious debt in whatever form already advanced by any owner is void, being violative of the Abolition Act 1992, hence not recoverable. As a corollary to that, all labourers working at bricklins are absolutely free human beings who cannot be restrained by the owners on any account. No owner shall extend, nor may a worker demand any amount of money except for the daily, weekly, or monthly wages as agreed in writing in the contract of employment. Any amount of money extended by an owner or a labourer for any exigency shall strictly be of a charitable nature and on a voluntary basis, hence not recoverable by the owner subsequently. No industrial, commercial, or agricultural establishment, factory, mine, workshop, business, trade, industry, or other place where any economic activity is carried on shall employ or permit a child below 14 years to work where the same is barred under the Employment of Children Act 1991. It shall also not engage any adolescent between the age of 15 to 18 years to perform any hazardous work in the establishment. A direction may be made for legislation on domestic workers' law for ICT. Till such legislation, Punjab Domestic Workers Act 2019 may be adopted for ICT, or one stop gap arrangement through executive powers may be made till appropriate legislation is or adoption takes place. The work hours of every worker labourer shall be in accordance with the relevant laws. In this regard, Section 7 of the Employment of Children Act 1991 shall be implemented in letter and spirit. The Chief Commissioner ICT may be directed to notify a District Vigilance Committee within 30 days in terms of Section 15 of the Bonded Labour System Abolition Act 1992. The DVC should meet at least once a month. The DVC and the Labour Department ICT should launch special drive and awareness campaign for workers, more particularly bricklanes workers, regarding their rights provided in the labour laws. The Labour Department ICT and ICT Employees Social Security Institution should take immediate steps for registration of bricklane workers and provision of social security benefits to them. This exercise should be completed within the next 3 months positively. The bricklane owners should pay statutory contribution to IESSI in accordance with law, and if they fail to do so, their dues shall be recovered with penalties under the relevant provision of law. The Health Department of ICT, in collaboration with the federal government, shall depute lady health workers to attend families of bricklane workers as on a regular basis and provide immunization to their children. The Federal Directorate of Education may be directed to ensure arrangements for enrollment of workers' children in schools and establishment of literary centers. The DVC should formulate an action plan to prevent return of freed labourers into debt bondage through relief, rehabilitation, welfare, and social assistance programs through targeted and transparent utilization of bonded labour fund as provided in the Bonded Labour System Abolition Rules 1995. The session judges Islamabad may be directed to nominate a dedicated magistrate for disposal of cases registered under the labour laws. Bonded labour, forced labour, and child labour should be directed to be on the agenda of every meeting of the Criminal Justice Coordination Committee. The said committee should review disposal of prosecutions under labour laws and issue such directions and take such steps as may be necessary for elimination of the menace of labour laws. The Chief Commissioner ICT may be directed to ensure implementation of Minimum Wage Ordinance 1961 in letter and spirit across the board. There should be zero tolerance for violation of the labour laws, particularly the Bonded Labour System Abolition Act 1992, the Employment of Children Act 1991, and the Minimum Wage Ordinance 1961. Criminal proceedings should be initiated for all offences. However, no legal harassment should be caused to any employer. In case of any complaint against any field officer of the Labour Department, ICT, or any other official, the employed may be free to have recourse to the legal remedies available under the law. The institution of Jamadar has been abolished by the Darshan Nasi case. This abolition shall be strictly enforced by the designated notified official under the Abolition Act 1992. All the labourers shall have direct dealings with their respective owners. No payments on behalf of the labourers shall be made to the Jamadars, nor recoverable, adjustable as per the directions of the Darshan Nasi judgment. The owners shall not directly or indirectly ask or pressurize any laborer for employing the women folk or children as per the direction of the Darshan Masi case. The Ministry of Information Technology should be directed to develop an easy to use mobile application for the laborers. After consultation with the Labor Department ICT, the mobile application should be programmed so that a copy of the signed contract may automatically be shared between the laborer, brick lane owner, and the Labor Department, ICT, and notified officer under Abolition Act 1992. Moreover, the application should provide an option for laborers to report any violation of their rights and or their terms of contract of employment to the concerned authorities. The Labor Department ICT should be strengthened in terms of manpower and financial resources in order for it to efficiently carry out its functions as prescribed under the labor laws. A consolidated single status like the Election Act 2017 on labor law should be drafted by the ICT administration with the support of subject area specialists and tabled before the parliament. Ideally, the law should be drafted in both Urdu and English. The enforcement and implementation of labor laws, instead of being scattered across departments, authorities under different labor statutes, should be entrusted upon a single authority. While drafting the new law, the Parliament may kindly consider the idea of having a single forum for inspection of all the various laws. Perhaps a new Office of Elected Labour Rights Commissioner may be set up and vested with this power. Appropriate legislation is required to strengthen the role of elected labour representatives with respect to policy making, oversight and enforcement of labour laws in ICT. The Labour Department ICT may be directed to ensure an enabling environment where the labourers employed in brick lanes may exercise the rights of unionization, collective bargaining freely with the support of all other relevant government authorities. The State Bank of Pakistan may be directed to explore and enact the appropriate mechanisms where victims of bonded labor, especially in brick lanes, may be extended the facility of microfinance banking. The regulatory authorities of media, both print and electronic, may be directed to ensure that public service messages should be widely broadcasted, published through TV, radio, and newspaper, emphasizing that vicious debt is root cause of bonded labor and wage slavery, which is illegal in ICT. Vicious debt gives rise to bonded labor system, which is also illegal. All laborers and their families who are restrained by their employers on the pretext of their obligation of repayment of vicious debt are under the law free to leave their employment and workplaces at will without any such obligation to pay vicious debt as the same is void. For those recommendations where legislation is required, laws of other provinces, if available, may be directed to be adopted or other stopgap arrangements through executive powers of ICT administration may be made till appropriate legislation is adopted. Sentences should be enhanced. Civil liabilities should be created, enhanced, and regulatory frameworks should be tightened against those owners of brick lane who are found to be in violation of the Abolition Act 1992. Thank you.